Welcome in here to Order in the Court on Queen City News Plus. I am anchor Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes. It's been a long time since I could say that.
Buddy, good to see you. It has been a while. And first off, tell our viewers here where you've been for the last few weeks.
I've been in court, trying to make sure I stayed in order within the good graces of the judge and having the jury liking me as much as they could. So, no, it was a real fun experience. Not just playing an attorney on TV, but actually being one in real life.
You are a working man for sure, working hard at it because you had a big case, obviously, here that lasted a trial that lasted several weeks. I know you were out for a week on prep, and then you had the trial itself.
Yeah, this was a lot, Brian. I mean, prep was probably more like 2.5 months. I was doing it, burning the candle at both ends. But that last week, I said, well, I got opening. I got to get ready for these witnesses. This is important. A person's life is in the line, so you want to make sure you're ready. And I think I was.
Yeah, and that's what you don't understand sometimes is being a defense attorney like you are. It takes a lot of work. You have to go through a lot of prep. You have to go through a lot of time because you do have somebody's life in your own hands.
Especially these types of cases that I do where it's life without parole. I don't think it's any other tougher gamble than that when you're saying, okay, the odds are really stacked up against you, and the risk which you're playing with, the risk reward is it's high.
And there's a justice that has to be served as well.
It is, and I think in this case, the most recent one, not to dig into the facts, but complicated situation, no winner and loser at all. Everyone was in a tough situation.
Well, buddy, court is in session right now. Let's just get to it because we got three topics that we talk about here. You're going to break them down. First off, this is a real talker, and it's very unique to the state of North Carolina, and that is where a TikTok influencer is being ordered to pay $1.75 million after a jury found her liable for destroying a Durham couple's marriage for the Alienation of Affection Act.
Yeah, this is these heart bomb laws that you have, and it goes back to the old days of like property, right? That your spouse was your property, and because your spouse at the time, your wife was your property, not now. I think the way they're interpreting this alienation of affection could be both ways, but in that time, it was your wife was your property, and because someone now has infringed on your property rights, you have a legal basis, a claim based in tort law to bring some type of remedy against them for wronging your property, right? And they've now given you some type of emotional connection or stress to that. I mean, North Carolina is not the only state. There's a number of other ones, Mississippi, South Dakota, New Mexico, Utah, and Hawaii that have it, but the overwhelming of the majority of states do not have these heart bomb laws in place. North Carolina still has it on the books, and yeah, it's a lot.
And break down a little bit about what happened here. North Carolina resident Brene Kennard, she's going to have to pay because the woman on the other end is saying that they broke up this marriage.
Well, you hit on a couple things. So first, let me tell you this. It's 4 elements. Every charge has an element to it. And for you to be successful in convicting or successful in winning in a court of trial, you have to make sure you meet the elements. So I talk about with tort cases, duty, breach, causation, and damages. Well, alienation of affection is similar to that. It was there a genuine love in the marriage, right? We're not separated. We're not divorced. We don't hate each other. We love each other. And then was there a malicious wrong act? Was there sex? Did you come and, kiss the person? Are you sending them letters? Like, are you doing some wrong, malicious act towards the marriage to now do what? To make sure that person loses affection. So not the person that's filing the suit, but the husband in this case lost affection for his wife. And because he lost affection for his wife, the wife is now saying this person's act caused his affection to be lost. Now, the key point, the last one, is damages. What type of damages is it? Was she the proximate cause, and did she cause damages? Well, it can't be enough to just say, okay, you hurt my feelings. You made me upset. This was not what I was expecting to happen in my marriage. But no, you have to have some treatment. You got to go get some therapy. There has to be a number of things that have been triggered. From this emotional and mental mind state, there is now a physical manifestation that has been expressed. And if you can meet those elements, you can get a trier of fact, a jury or a judge to fall in your way.
Well, the burden of proof there, how do you prove, because it's pretty pretty steep, I would say, because you have to prove a lot of that there because unfortunately, there's divorce all around the world. And in the state of North Carolina, there's people sleeping with other people and infidelity. But the proof to have that law, to enact that and have the jury decide, and it usually are large settlements because we've seen a lot of other large settlements with this type of case.
$9 million, $5.9 million, $30 million, all in our state. So you've seen some large settlements right here in North Carolina, and you've had some big people be involved. You got obviously this Kennard. You got Tim Moore, ex-Speaker of the House, now U.S. Congressman. And then you got former Real Housewives of Atlanta, Nene Leakes. Those are people and she got sued in North Carolina. Huntersville woman sued her. So those are the types of things that are happening where you get big lawsuits.
NFL star Fletcher Cox.
My Philadelphia
by North
Eagles.
Carolina man, yeah.
Eagles, they sued by, and guess what? Fletcher Cox, he that was an easy case to prove. So you ask the question, how do you prove it? Text messages, phone calls, right? That's going to be the malicious act portion. Do I have you on video? Did I catch you in the middle of the act? That's going to be the easiest way. Then to be able to prove that we had a loving relationship, were we divorced? Were we separated? Were you still living under the house? Like, that's going to be easier to prove as well because either you had another place or you didn't. Now, the husband could say, well, I wasn't living in the house anymore. Or I may still live there, but we lived in separate rooms. That's kind of getting into the smaller details. But the easier thing would say, hey, man, we were separated. I had a whole nother apartment. Then you clearly couldn't have been, in a loving, genuine relationship. But I think that's going to be the hardest part in these cases. Was there a malicious act? Were you guys in a loving relationship? And then did you cause me to lose that love? And that the damages part's easy. Did you go to the doctor? Were there, were you having nightmares? Are you having tremors? Now, do you have some type of PTSD? Is there something that has been created after this wrongful, malicious conduct that now causes your spouse to not want to be with you? And now has their not wanting to be with you triggered some emotional distress? Yeah,
it is certainly an interesting case and not a law that's only used in 6 other states as you're talking about. But in this case, $1.75 million, and whether you get that money or not, it's still the civil judgment against them.
I tell you all the time, Brian, you don't want to sue anybody that don't have any money. Right? You don't want to bring a lawsuit against somebody that's like, the guy that's always asking you to borrow money. That's not who you sue. You're going to sue big companies. Or in this era of social media, of TikTok, of influencers, this person was an influencer. Mm-hmm. She has a really huge following. And because she has a huge following, I'd assume that every time she posts a video, those videos will, generate revenue. Mm-hmm. And that revenue now will ultimately be turned over to this other individual. Now, last thing I'll say is you talk about what do you have to prove. Sometimes being a social media person hurts. Because in this scenario, the plaintiffs used this woman's videos from her social media where she said, I knew what I was doing was wrong. Ooh. I knew that it was going to cause her some heartache. Well, I can point to you saying you knew this was something that was going to break down my marriage. I don't have to guess your thoughts.
The jury didn't have a hard time deciding on that.
They did not. They were not out long. And the last point I'll make is that the plaintiff's attorney made an excellent point. How much does it cost to break up a marriage? And that's the question she left the jury to decide. And obviously they came back at $1.75 million.
Well, a lot of people that's going to pull on their heartstrings for sure. All right, that's going to wrap it up for our first topic today on Order in the Court. Khalif, when we come back, we're going to be talking about the Laken Riley Act. Obviously, Laken Riley murdered in the state of Georgia. A lawmaker is very upset. Everyone very upset about what happened and the nature of that. But the law that was enacted may not be being used the way that it was intended, and we'll talk about that coming up after the break. You're watching Queen City News, Order in the Court on Queen City News Plus. Welcome back to Order in the Court with Brian Blakely and Chief Legal Analyst Khalif Rhodes. We're talking today about another topic, Khalif, and that is the Laken Riley Act. Some judges, they're using that right now in the opposite way that it was intended for, to release immigrants from ICE custody. The law, it gives immigration agents the authority to take illegal immigrants into custody if they've been arrested for or convicted of a violent crime. But you say that's not the way that some judges, how they are interpreting this law now.
Well, again, and I've mentioned this before, You know, I'm not the best with Latin, but in law school they teach you these Latin terms. You're supposed to remember some of them. A judge can raise something on their own. It's called sua sponte without being motioned or positioned by another party in the claim. I don't believe that's what's happening in this case. Judges aren't deciding sua sponte. Hey, this case is in front of me. I'm going to make this determination. Typically, it's going to be a petitioner, someone that already has a detention hearing, someone that is already being up for removal, and now they're challenging. They're saying that this is something where I'm being removed unlawfully, and I'm being removed unlawfully under what folks are now using to remove people. This Laken Rowley Act was, okay, I'm going to give these ICE agents the authority that specifically grant you the power to detain people, to arrest them if they are convicted or arrested of crimes. Okay, so that begs the question, if I have to use Congress to grant you this power and authority, did you not already have it first? And do you have broad arresting powers? And the answer the court is saying is no. You don't have broad detention and arrest power. So if you can detain non-citizens, right, that have criminal charges or have been arrested, the logical next step is that you don't have authority to detain non-citizens without arrest or criminal history. And that's what the courts are following. They're following the argument that because their authority isn't broad, because it isn't, unlimited, that Congress has given them a narrow and specific power, that specific power is granted for them to only be able to detain and arrest these folks that have been arrested or charged with a crime. So that means on the flip side of the coin, you can't touch these other people. And that's what the arguments have been. And I think those are valid arguments, something that has been used throughout American history. When something comes up, affirmative action is probably the best way I can describe it. We have all these colleges getting sued because they weren't letting and admitting African Americans. 20, 30 years later after affirmative action, white students are saying, hey, that same law you used to allow these students in, you're reverse discriminating against me. And courts have said, you know what? You're right. Those are what I think is happens when you have people that are crafty and skillful with trying to find ways to maneuver within the legal landscape.
So what needs to happen going forward then with this? Because how do you have this to where you get a clear ruling of how the law is implemented?
I think right now this is probably the clearest way it can be. And it's clear as mud. It's not
unless you go back to Congress and have them retool it a little bit.
Congress could attempt to do that and give and broaden the powers of ICE, but you don't want that to happen. Think about before all these things happened with the Trump administration. Prior to the Trump administration taking over, ICE would only detain and or arrest you when you're in the country if you had been convicted of a crime. That was right on the website, right on Homeland Security and ICE's website. When Trump administration came in, they talked about the largest deportation in American history. They started arresting people that were just charged with crimes and not convicted. And so that's already something that the court has said you guys don't have authority to do. So Congress steps in and gives them this sweeping authority to do it based on this Laken Rowley Act. So that's there. But we try to make a complicated situation extremely simple. And it's not as simple as black and white. Remember, people that are in the country right now, today, if they came here through whatever process, the process of being in the United States as an illegal alien, as a non-citizen, it's not illegal. Their unlawful presence is not illegal, right? It's a civil action. You can sue them. Now, if they have violated the law and attempting to get through and avoid some type of scan, got in here and I saw a check-in system to the left, I went to the right. Yeah, that's a misdemeanor and that's a problem. Now, reentry after being deported, you come back into the country. Yes, that is a felony. But the overwhelming majority of people that ICE is detaining and bringing in don't fall into that category. What they do fall into the category is non-citizens with an arrest record or not. And in this case, the folks that don't have a conviction, that haven't been charged with a crime, the courts are saying, you got to release them. They're entitled to a hearing. They're entitled to due process. And because they're entitled to that due process, without meeting the minimum requirements of what the law has implemented, this law that was supposed to strengthen and give, stronger reinforcements to national security and for immigration. It hasn't, based on what this is saying, it has added a loophole, I should say, to ensure that now folks can find ways to stay in the country even if you're unlawful.
Well, it's a story that we'll keep following and see how that progresses, if there is anything that's done to make changes to the law going forward, and if it will stay that way.
And Brian, let me say this before we go, man. This law was implemented as typically things are in this country in a reactive mindset, right? Something horrific happened, a terrible situation that I would never wish on any family occurred. And in response, Congress acted as they should and implemented a law that they thought would make our streets and our country safer. Now, because the writing and the wording of the law has allowed for people to still find ways to be here, you have to remember ICE is not an arresting agency. What they're attempting to do right now is to give them additional power to implement what the president is asking them to do.
All right, we'll leave it there for right now, and then we'll take a short break. When we come back, though, Khalif, we're going to be talking about a transgender TSA officer that is now suing over some of the new policies that have been enacted under the TSA administration. You're watching Order in the Court. We'll be right back on Queen City News Plus. All right, welcome back to Order in the Court here with Chief Legal Analyst Khalif Rhodes and myself, Brian Blakely. Last topic we're going to talk about today, Khalif, and that is a transgender TSA officer at Dulles International Airport is suing over a policy barring transgender officers from conducting pat-downs and using gender-aligned restrooms. This is a new policy enacted in February under the Trump administration.
Workplace discrimination. I mean, it seems like it's explicit on its face. Because transgender would be considered a protected class, you can't do something that's going to be discrimination based on sex. I mean, it's on the basis of sex. That's at the core of what any of these lawsuits have been over the last probably 3 or 4 decades. And that was primarily for women suing that their rights were being infringed and frozen and chilled. And so now they're using, I talked about it earlier, using laws that were implemented for one thing for another thing. So now you have people that are saying, hey, the same rules that applied for women in the 60s and the 70s and the 80s, I want you to apply that same standard to this situation for me because now I have been granted a protected class status. Now, if this would have been 20 years ago, transgender rights were not protected class. And because they weren't a protected class, I think this lawsuit would have been dead on arrival. But now, because you're a protected class, you got workplace discrimination. You got operational impact on TSA. You got legal precedents on gender identity. I mean, public facing screening. There's a number of things that are happening in this case. I mean, all you have to do when you're looking at this case is you put a person that's not a transgender up against a person that's transgender, and you say, when I apply the rules that we have on the books, do they apply equally to both people? And if the answer is that they do not apply equally to both people, then it's discrimination on its face. And that's what you're asking the court. You're saying, I don't even have to prove a deep case. I can say this is per se discrimination because on its face it's discriminatory. Just if you say, did you apply the standard equally to both? And that's the same standard that you used when you did women's cases back in the day. It was, you got a male here, you got a female here. Did you treat that male different than you did the female? Did you allow them to get access to promotions? Did you allow them to do pat downs? And you can see the answers clearly yes in this scenario. When Trump rolled out this new executive order that it would be only male and female distinctions in the federal government, it had a ripple effect. And one of those ripple effects was TSA now. Well, there's not a distinction for transgender. And because there's not a distinction for transgender, you're not going to have an ability to do your job, limit your growth potential, limit your ability for raises. Because if I got to give you a portion of the job to do and you can't do the whole job, you're significantly hindering my ability to promote and go up in the company.
But here's the thing. TSA says, and here's the comeback for them and why the law and the executive order was established. And it says the policy ensures that passenger comfort by matching officer sex to traveler sex.
Yes. Yep. That's the response that TSA has said. And the transgender individual that filed claim would say, listen, this is my identity that I have identified as. And so prior to the Trump administration changing this rule, I would have been able to pat down the person that I identify the gender with now. And that is the change. That is where you're seeing a discrimination on its face towards a transgender person.
Well, then where do you think this is going to happen going forward? Where do you think this case goes? Because I know when you always talk about this will settle. But now you're talking about the federal government that enacted this law.
Well, if I know anything about this administration, I don't think they're settling anything. I mean, so let's start there. This is an administration that believes that when they implement a rule, when they start something, they're going to finish it. So I think this is one that goes the distance to the Supreme Court at some point if granted cert. I think it goes to the United States District Court. I think it goes to the Court of Appeals. And then ultimately, whatever side is successful or unsuccessful will challenge this to the Supreme Court. Then the court will have an opportunity to grant cert or not. Remember, 90+% of cases, 99% I should say, are rejected. They get 6,000 to 7,000 cases submitted every year and only accept 60. That's 1%.
Yeah.
So that's not many. And so you got to have good facts. You got to have good timing. You got to have a court that wants to hear it. Now, I'll say this. The court wants to hear this type of case. This rendition of the Supreme Court wants to hear transgender, LGBTQ types of cases because they want to have and make their mark on those types of cases. I'm just not sure if the facts will line up and if timing will line up. A case like this may take 5 to 10 years to get to the Supreme Court.
Yeah, so it's a long time coming, but the TSA officer in question here will have to be ready to endure that, and a lot of also, challenging times ahead for that person.
And cost.
And the cost.
Yep.
All right, that's going to wrap it up here for all of us here at Order in the Court. Chief Legal Analyst Collie Froze, it's good to see you again. Good to get together again, do our show.
That you are the guy, so I'm just happy to be sitting in the seat back with my day one guy.
Yeah, nice. I love it. And then good luck on your son's wrestling match. I know it's a big one coming up tomorrow, and we're going to be following that too because we'll have the results, and hopefully it'll be good next time around. All right, thanks for watching. You're on Order of the Court and Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.